Hey guys, it is me. It's Mr. G, your favorite online criminal justice instructor. And how do I know I'm your favorite online criminal justice instructor? Because I'm the only online criminal justice instructor. So, anyway, here we go. We're into week 3. Everybody's been registered now. Don't have to worry about doing drop ads and stuff anymore. So we're going to get rolling. I've sort of kept things a little bit slow to make sure everybody gets in and folks coming in late last week. In fact, I actually do have some people that are starting like Monday will be their first day of being registered. So I kind of slow rolled it a little bit. You've gone through a little bit, gave you a little bit to chew on. But not a whole lot of requirements. So now is the first week which we're really going to get into depth and start hitting stuff. But it's still not going to be extremely fast paced because, again, this is a long semester. We have all of September, all of October, all of November, and that first week of December before we have to roll into finals for this course. So we got a really long time to learn a lot of stuff. Nothing to worry about. We'll get it all, and I'll keep it slow enough so we enjoy the class and you're not being rushed and feel like having to digest things rapidly. So, we've already hit some stuff, so I'm going to review a little bit, and then I'm going to get into where we want to be up to date, okay? And we're still kind of in Chapter 1. We are pretty much all in Chapter 1 right now. If you have a book, if you didn't pick up a book, don't worry about it. I'm going to give you everything you need, and if there's something I want you to have, just definitely out of the book, I'm going to post it in with my lectures and videos as a media attachment. So I'll scan in anything I need you or really want you to have out of the book into here. So if you don't have one, don't worry about it. For those of you that have one, it's good to read through and to look up stuff and kind of just give you little things if you like to just have a book and read it. But if you didn't get one so far, don't worry about running to the school and getting one. So first thing I want to do is sort of you follow through the book. You've gone through the court systems. We've talked about the federal court system, and I believe I posted an example of how the federal court system works and the state court system. But I'm going to talk about a little bit of the reality of how the court system works, and we'll go through that whole process, okay? So if you think about where we are, if you think about, let's say you go to America's campus and you're in Sumter County, or to go to the Cordell campus and you're in the Crisp County, there's multiple kind of courts that you may be involved with. First of all, there's municipal courts. There are municipal courts. And if you say, well, what is a municipal court? Well, if you're in the city limits of Cordell or the city limits of Americus or the city limits of whatever town you live in, and you commit a misdemeanor crime, and it's all misdemeanors in municipal courts, you will go to that court system. And when you hear municipal, basically that's a word that refers to the government of that city. So a municipal court is a court that represents the government of that city, and they enforce city statutes as well as state law. Okay? So what's a city statute? Well, let's say your city council gets together and says, we don't want any teens out on the street past 11 p.m. Sunday night through Thursday night. And your teenager, 14 years old, is out at 11:30 at a convenience store, and a police officer sees him, brings him over, puts him in the car, drives him home, writes you a citation to come to municipal court, and you get a $50 fine for breaking curfew. Well, that would be an example of a municipal ordinance for which you would go to to municipal court on. And the way municipal court judges are seated is the city council will vote for them, just like they'll vote for a chief of police or any other position. They will vote and appoint a municipal court judge, and normally it's a local lawyer from there in town, and they'll have them sit and hear over the municipal court. So you have the municipal court system. It's a misdemeanor court, and it represents the city ordinances and statutes as well as misdemeanor state laws that occur within the jurisdiction of that municipality. Okay, so I just brought up jurisdiction, so let's kind of talk about that as we're going into courts. You've all heard the word jurisdiction. And what does jurisdiction mean? I can't hear you guys. Speak up a little bit. Jurisdiction. You're raising your hand over there. Who are you? I told y'all before, I can't hear you. I can't see you. You're all silly kids. I love doing that. I like to make myself laugh. So anyway, jurisdiction. Yeah. What jurisdiction means is, for example, the City of Americus or the City of Cordele Police Departments. Their jurisdiction is the city limit of that town. That's where their legal authority to enforce the law resides. So an Americus or a Cordele police officer, their primary jurisdiction is within that city limits. That's why you don't see city police cars out patrolling in the county, because that's beyond their legal jurisdiction, meaning that's beyond their legal area where they can enforce the law. Okay, a county deputy for the sheriff's department. Okay, and everybody likes to, and you know, in down south, everybody calls anybody who works for the sheriff's department a sheriff. Well, there's only one sheriff, just like there's only one chief of police. That'd be like calling every patrolman a chief. There's only one sheriff, and I know we use it for, everybody refers to anybody who works for the police department as a sheriff. There's only one sheriff. Everybody else are deputies or a chief deputy. A chief deputy would be like the assistant chief of police. Okay, so you have deputies in the county. A deputy's jurisdiction are the county boundary lines. So wherever the boundary lines for that county are, that's the legal jurisdiction or the area in which that deputy or the sheriff has authority to enforce law. Stays within that county. Okay, now since we're talking about that with the city and the county, can a city police officer go out of the city limits and make an arrest? Yes, if they're making an arrest for a crime which was committed within their jurisdiction. So let's say that somebody in Cordele or Americus commits a crime, and then they head out to Lake Blackshear. If it's in the city limits, can a city police officer go out there and make an arrest? Yes, they can, because the crime originated within their jurisdiction. But if the crime was outside the city limits, a police officer cannot get a warrant nor make an arrest on that crime because it's outside their jurisdiction. They would need to turn that over to the county so that a deputy or the sheriff can make that arrest. Okay? Now, if something happens in Sumter County or something happens in Crisp County, can a deputy go outside of those two counties and make an arrest? Yes, you can go to any other county in the state of Georgia and you can make an arrest because you're sworn by the state of Georgia and you're making an arrest for an incident. But again, wherever you go, you want to get that local agency involved to help you with that arrest. Now, let's talk about the GBI State Patrol. Probation officers, all those other state guys who have legal authorities of arrest. What's their jurisdiction? Exactly. You guys are right. Their jurisdiction is the state of Georgia. So any crime that originates within the state of Georgia, they have the authority to make an arrest on. Now, if you go outside of the state of Georgia and you're a municipal police officer, a county police officer, a state police officer, and you're sworn in the state of Georgia and you want to go outside of Georgia to make an arrest, can you do that? Only in conjunction with officers from that other state, unless you have a reciprocal arrest agreement with another state. For example, Georgia used to have reciprocal arrest agreements with Alabama, Tennessee, North Carolina, South Carolina, Florida, the neighboring states, saying that you can come in and arrest, you can make an arrest of a person who committed a crime within your state, in our states, and we'll do that. And the reason states do that is, let's say you live in Columbus, Georgia, for example, and Columbus bleeds right over the river into Phoenix City. It's essentially one metropolitan area, but it crosses over into another state. So you're going to have a reciprocal agreement where you can go in and make an arrest, and again, you're going to notify that other agency, that either the sheriff's department or the Alabama Bureau of Investigation or whoever it is, and say, hey, I'm coming over into Alabama. I think my guy's over here and I want to go make an arrest. So you're going to do it in conjunction with them. You're just not going to go over and do it. But you can make an arrest outside of your jurisdiction. So again, we're talking about municipal police officers, meaning city police officers. Their jurisdiction is restricted to the city limits of the town for which they work. We're talking about county police officers, deputies, or the sheriff. Their jurisdiction is restricted to the county for which they're sworn to serve. Okay? And if you're talking about state law enforcement officers, their authority is the legal limits of that state, meaning they can go anywhere in that state and make an arrest. Now, if you talk about federal law enforcement officers, what is their jurisdiction? Their jurisdiction is anywhere within the United States and its territories. So Puerto Rico, Guam, those kind of things. A federal police officer would still have legal authority to make an arrest, except for, here's the exception when it comes to federal police officers, where they have jurisdiction, but they don't have the legal authority to just go in and make an arrest. Okay, so there are spots within the United States that a federal police officer may have jurisdiction, but is not able to go in and immediately make an arrest. And can anyone tell me what those areas are? Native American reservations. And why? Why would the federal government not have, although they have some jurisdiction there, why would they not be able to just go in and make an arrest and operate within Native American reservations? Because the federal government has set those aside as independent nations. So, for example, I have Creek Indian heritage, and the Creek Indian heritage, or the Creek Indian Nation, is over in the Columbus, Opelika, all that side of Alabama is where the Creek Indian Nation is. And it's considered, if you are a Native American and you are on the official reservation or nation territory of that tribe, that is considered its own sovereign territory, although it is within the United States. So, would the FBI have the ability to go in and investigate something, or DEA or whatever? Yes, they can come in and investigate, but normally it's only if the tribal authorities call them in or they get special sanctions to do it. So there is area within the United States where the federal law enforcement guys can't go just jump in, and it's only because those Native American nations are considered sovereign within themselves. Basically, they're saying you are your own nation, and we're going to theoretically treat you that way, unless for some reason we have to supersede that and come in and do an independent investigation. Okay? So hopefully that clears up jurisdiction for you and you understand. So when we go into courts, you really need to understand jurisdiction, because you're going to have to know under which jurisdiction your court resides to make sure it goes into the right thing. So we started all this long discussion off with municipal courts. I think we explained that and we know that pretty well. Now, you have your county court systems, which you have several. You have probate judges, you have magistrate judges, and you have superior court judges. Okay? Probate judges are going to do more civil issues like resolution of wills, of land deeds, of those kind of things. So your probate judges are going to handle more civil type matters and hear those cases and resolve those cases. So in a county, that's what your probate court judge would normally reside over, would be civil matters, or matters like wills, deeds, those kind of things. Your magistrate judge is going to do things like your arrest warrants and pretrial hearings and smaller criminal type cases and things like that, okay, for the county. All right, so just like when the county police officers write a ticket, it can be either the probate judge or the magistrate judge. They'll bring them in to work those courts, and it really depends on the county on who does it. I know in several counties the probate judge does all of it, and the magistrates just basically writes your warrants. And in other counties it's different, where it's totally split up. But that's where you'll need to know where that jurisdiction lays within your county. They're elected officials. They run for office. You'll see the signs up during election years. But that's what they sit over. And then your primary court for trial would be your district court for the state. Okay? And your district court normally happens in jurisdictions in our region about once every 2-3 months, normally once every quarter, so once every 3 months. And then in that time frame, they may hold court for a week or 2 weeks, depending on what the docket looks like. And when I say docket, what the docket is that judge is going to have a list of all the cases that are currently open that he needs to see at the time the court comes up. And normally they're listed by date. And the reason they're listed by date is, you've heard, of course, we start off with the Bill of Rights and some other stuff in there. And so you have the right to a fair and speedy trial. Well, the idea of speedy normally means that by the time you are indicted by the grand jury, that's sort of been covered previously. So by the time you're indicted by the grand jury, they're going to give you about 2 years to get that case to trial, to fall within that fair and speedy trial window. Okay, so the judge is going to have a list of all the cases that still fall within that 2-year window. So when they go and they start doing their pretrial motions and things like that, what that judge is looking at is, okay, which of these cases do I really need to hear before they hit that 2-year window? And so he may look at it and say he's got 2 or 3 homicide cases. Well, he knows he wants to try to get those to trial. And he's going to get with the defense lawyers and with the prosecutors. He's going to try to figure out, okay, how many days do you think it's going to take us to try this case? Because I'm here for 2 weeks, so can we hit these 3 murder trials and then maybe a couple of rape cases or something like that in this run of court. And if they say, yeah, well, I think we can, let's bring these 2 murder trials and, we've got 2 rape trials we can hear during this session of court. And the rest of them, okay, so we've got 300 cases left still on our docket within the 2-year window. So what are we going to do to try to resolve these? How many of these cases can we go ahead and plead out? Does everybody know what plead means? I know everybody knows what it is. Plead is basically where you tell your client, okay, if this goes to trial, you may get 25 years with possibility of parole in 20. And if we plead it out, I think I can get the DA to agree to 12 years with possibility of parole in 8, which is a lot less than what you may get if you go to trial. But the thing is, if you plead to this, you're saying, I'm guilty, and you waive all rights to appeal. That's significant. Meaning, and why is that significant? I'll tell you a couple of reasons. First of all, if you go and you plead out and you waive your rights to appeal and you say, I'm guilty, that's it, whatever, then that case is closed forever. Means they don't have to worry about pulling it back up and it running through the appeal process and tying up other court systems and all that. So they really want to plead it out. And secondly, because remember, judges and district attorneys are appointed. So what they never want to happen is they never want a case that they have tried and got a conviction on to go on and being appealed and overturned. So if you get somebody to plea out, not only do you clear your docket and it gives you a higher rate of convictions, because a plea is a conviction because they plead guilty, they're convicted of a crime. So if you get them to plead out, it gives them a higher rate of conviction, plus it eliminates the risk of a case being overturned on appeal. So if you're on the prosecutor side, a plea agreement is very attractive for those reasons. If you're on the defense side, you never know what's going to happen in a jury trial. So even if you're innocent, if they have a case that makes it look like you're really, really guilty, you may feel pressured into pleading to a crime, or if you know you're guilty, you may want to go ahead and plead to the crime because at least you could control your sentencing better, and it's always going to be a little bit lesser than what the harshest could be, because you never know. You may go to trial and things just go really south for you and you're gone forever. So when you do go to trial, when you go to a superior court or circuit court or district court, it's all the same thing, just different names we call it. When you get to that level and you look at the number of cases, statistically, it's only about 2 to 4% of the cases that are on that docket ever go before a jury. Okay? Again, it's only like 2 to 4% of all cases that are on the court's docket actually go before the jury to be heard. And normally those are your most serious cases. Okay? Now, what they may have with the other case, you can say, well, what happens to everything else? Well, the other 96 to 98% of cases are A, pled out, or B, dropped. And what does dropped mean? Well, let's say you're getting close to that 2-year window where they're saying, okay, if we're going to meet that speedy and fair window, we've got to bring you before a jury in 2 years. And let's say, so if you meet every quarter, there's 4 quarters in a year. That means there's 8 court sessions within a 2-year period. Well, let's say it's the 7th court session for that your case has been on the docket. Nobody's ready to take it to trial. They still don't have any more evidence. What that district attorney may do is they may say, okay, well, we're going to go ahead and drop all the charges against this person at this point because A, if we take it to trial, we're not going to get a conviction. B, they may decide, you know what, we're never going to get any more to get a conviction. Or C, they may decide, hey, you know what, we may still get there's a lot of stuff out there, and we may still get a lot of evidence that's going to make our case really strong where we can bring it back later. So if they drop the charges and then say 7-8 months later maybe they get a DNA hit, and that leads to them going out and talking to other folks and them getting some eyewitness statements and getting stuff that they didn't have during that first period. If you drop charges against someone, you can always go back and bring those charges back against them. So that's the beauty of dropping charges. It's not double jeopardy because they never went to trial. They never got to the trial process, and they never plead out to reach an agreement. So you can drop charges against someone, continue to further that case, and then come back at a later date, take them back before the grand jury with the new evidence, get them re-indicted, and then take them to trial. So again, with your superior court, district court, circuit court, it's all the same thing. With that process, 2 to 4% of cases are actually going to go to trial. Okay? The rest of it, that 96 to 98% of cases that don't, are either going to be what? Pled out or dropped, to either be dropped because they know they're never going to get enough to prosecute that person effectively, or dropped to continue to build evidence so that they can come back at a later date and get a new indictment and then take them to trial. Okay? Does that all make sense? I hope so. So, once you get through Superior Court, your county court, and your trial's been heard, and you've been convicted, or you've pled, what's the next step? I think some of you got it. Remember, if you pled, what do you not have the right to do? Appeal. Normally, every plea agreement, you have to agree to waive your right to appeal, which means if you're pleading to 20 years to do 12, then you're going to do, and when I say 20 years to do 12, what that means is your sentence is 20 years. If you've reached the 12-year mark and you've not had any problems in prison, you've been a model prisoner, everything's going good, you can go before the parole board at 12 years and be paroled. It's what 20 to do 12 is. Sorry I threw that out without explaining it. But that would be, if I say 20 to do 12, that's what that means. So if you pled out to 20 to do 12, you don't have the right to appeal. So after that point, you're going to spend at least 12 years in prison, and then you can start going before the parole board and start asking for parole. Okay? And if you don't get paroled at that point, then at 20 years, you walk out the door and you're done. Okay? Now, if you went to trial and you were convicted of your crime in trial, you go, if it's a capital case, meaning it's the death penalty, there's no option. It immediately goes into appeal. So if it's a capital crime, which means it's a death penalty crime, and in some states, if it's death or life sentences are automatic appeals too, meaning they're not even going to ask you. There's no question. They're going to automatically roll that case up to the appellate court, and the appeals court is automatically going to review your case. Okay? If it's capital or a life sentence, too, in some states, it's automatically going to go for appeals. And what does appellate court means? It means that that appellate court is going to review what happened, and not so much guilt or innocence. Now, it's not like, because remember, we can't have double jeopardy, which means they're not going to review it again, just like they're not going to review it again and try to convict you again. They're not really going to review it to determine innocence. However, they can if let's say they can prove that the DNA was flawed or whatever, and it goes up to appeals, and that's part of your appeal. Then yeah, they may say, well, no, this guy was innocent, you got to let him go. A lot of time what your appellate courts are looking at is constitutional procedure, meaning was the way your case carried out adherent to the Bill of Rights. And we've already gone over the Bill of Rights, but that's what appeals courts are most likely going to be looking at is, did he have proper representation? Was his trial fair and speedy? Did he have the right mental capacity to understand what was going on? All those little things that are under the Bill of Rights, his constitutional rights. That's what the appellate court is going to be looking at. And why would the appellate court be looking at those issues? Because first of all, that's what the Bill of Rights are for, right? So they want to make sure it's followed. But if you continue to carry that up and it goes through the appellate court and then it goes to the Georgia State Supreme Court, if they uphold the conviction, then the next place to go is, so it would go from Superior Court, then you appeal to appellate court, and the appellate court upholds the conviction, you would take it the next step to the Georgia State Supreme Court. If they uphold the conviction, your final step is going to be to appeal to the U.S. Supreme Court, to have the U.S. Supreme Court review your case. And what's the only reason why the U.S. Supreme Court reviews cases? Constitutionality. Exactly. They're going to follow that case, and they're going to, if they agree to hear that case, they're only going to be reviewing it for constitutional process, meaning was this person's Bill of Rights adhered to during his entire trial court system? Were his rights violated in any way? Because they don't decide guilt or innocence. They only determine the constitutionality of that verdict, of that decision. Okay? So if the Supreme Court hears a case and they decide that a person's rights were violated, they don't go back and say, no, you're innocent, you can walk free. It's not the way the Supreme Court works. What they'll do is you'll hear where they rendered a decision back to, let's say, the Georgia State Supreme Court. So what would that mean? What would it mean if I send a case back? If I'm the U.S. Supreme Court and I send a case back to the Georgia Supreme Court or the Georgia Appellate Court, it means that I didn't agree with that process. It means that we don't believe constitutionally it followed the law. So they're going to send it back to the court of jurisdiction, which would be either the Georgia Supreme Court or the Georgia Court of Appeals, and they're going to give their decision, meaning the Supreme Court justices are going to write out a paper to that court and say, this is why we feel this person's rights were violated. You need to go back over this case to determine whether we're right or not and rethink your decision. So they're sending it back basically when you hear that something's been sent back. The Supreme Court's telling the lower court that they were wrong. And they're wanting them to review their decision again and basically change it because they're not going to change it themselves. They send it back to the court of jurisdiction. Does that make sense? I hope so. If not, hit me up. Text me and say, hey, Mr. G, I'm in the middle of this video and my brain's leaking and you melted it and I'm really confused and I need help. So please help me now. Is there something I can't do? Anyway, I should have been a singer. I know that. I should have been a model. I should have been a singer. There's so many things I should have done, and I didn't because I wanted to be here at South Georgia Tech teaching criminal justice online. So aren't you fortunate? I think so. That's my thought. So, federal court systems. When we look at federal court systems, we look at jurisdiction of federal court systems. I think we already posted that last week, and you saw there's different federal courts, and that works out kind of the same way. If you commit a federal crime, which you already know, the state has their laws, and then there's federal laws. If you're convicted of a federal crime, you're going to start out in a a federal superior court, district court, and you've seen the map of that already. And then it works the same way. You go up to the federal appellate court. It's just instead of going to the state Supreme Court, you would go through your federal district court, your federal court of appeals, and then your last step would be the U.S. Supreme Court. Okay? Now, I want to talk about sovereignty and dual sovereignty and those kind of things, because I want you to understand what dual sovereignty is. I want you to understand the differences in laws, and I'll talk about one of the primary examples of what's going on now with dual sovereignty. And if you do have a book, Dual Sovereignty is on page 12. If you don't have a book, Google it. It's DUAL SOVEREIGNTY. I had to look at that because I always screw it up. Sovereignty is spelled so wrong. So it's DUAL SOVEREIGNTY. Dual sovereignty. Okay. What that means is the federal court can make a law, and if it's the federal, and this goes back to the 14th Amendment. So go back to your bill. We had the Bill of Rights, which was traditionally the first 8, or the first 10 bills, right? Or the Bill of Rights, First Amendments. Okay. Go back and look at the 14th Amendment, and the reason they did the 14th Amendment was post-Civil War, and they were trying to rectify the whole deal with slavery. And let me give you a little bit of history right now, because to understand the 14th Amendment and why we need the 14th Amendment, you need to get through a misconception of history. When we talk about the Emancipation Proclamation, everybody's taught, and historical lore will lead you to believe that Abraham Lincoln freed the slaves with the Emancipation Proclamation. It didn't happen at all. The Emancipation Proclamation is a mute document. And when I say mute document, what I mean is it had no authority whatsoever. And why? Why would you say that? And again, I know some of you might be getting, ooh, I don't believe that. I want you to go look up the Emancipation Proclamation and read it, and read what it says, and then come back and listen to this, and you'll see I'm right. When Abraham Lincoln wrote the Emancipation Proclamation, the United States was divided. It wasn't the United States at that time, right? It had been America, okay? But at the time that the Emancipation Proclamation was written, there were two nations in America. There was the Union of States, and there was the Confederated States. And these were two separate nations with two separate presidents that were at war with one another. Okay? Because the southern states had seceded from the Union, meaning they had separated themselves from the Union and declared themselves an independent nation and brought in their own president. So there were two countries divided. Is that clear? So if the president of the Union States, Abraham Lincoln, writes a paper and says, I'm going to free the slaves, his statement, his document is only valid for his nation, for the states under his control. So the Emancipation Proclamation to free any slaves would only be valid in the Union States. However, Abraham Lincoln specifically does not free the slaves under his authority. He frees the slaves, or the document says he would declare the slaves in the South to be free and would give them passage through the northern states, at which time northern slave owners would capture them if they saw them, which is why we had the Underground Railroad. If you were a slave and you thought you were free in the South and you went to the North, guess what? You're going to be recaptured as an escaped slave. Thus, the Underground Railroad didn't end at the Mason-Dixon line. It ended at the Canadian border. The Emancipation Proclamation only stated freedom for the Southern, the Confederate states, and Abraham Lincoln had no authority to free slaves there. And he didn't do anything for the slaves under which he had control, the northern slaves. So I want you to read that and understand the Emancipation Proclamation was nothing really than a tactical move by Abraham Lincoln to create an uprising by the slaves in the South to help put an end to the war, is all it was. It wasn't a statement of freedom. So we later come in and we have the 14th Amendment to the Constitution, and it's where you basically have the groundwork to free the slaves. And what it gives is it gives the authority of the federal government to write law that is sovereign over the whole country. So what the federal government, to get back to the law and out of history, the federal government has the right to write a law that covers the entire country. And the states, what they can do is they can come back and write a law that is more stringent, meaning it's more restrictive than the federal law, but they can't write laws that undermine or lessens the federal law. Does that make sense? So a state can make a federal law more stringent, more strict, more severe, but it can't lessen a federal law, okay? And what's a good example right now? Marijuana, okay? People say marijuana is legal in Colorado, it's legal here, it's legal there, it's legal. Well, right now, it's not legal anywhere in the United States, and in fact, Congress just voted last month again to keep marijuana on the same restrictive registry as heroin under federal code. So, under federal code, marijuana is still just as illegal as heroin and all these other, I think it's type A drugs, okay? Now, states are going out and saying we've legalized it and they've got these industries now and all that. Well, that's only good as long as the federal government isn't actively prosecuting it. And the federal government isn't, because the current administration is kind of like pro-marijuana use. I mean, the president's open about having used marijuana in the past. He doesn't agree with our drug laws. And so the federal government currently is not prosecuting the use of marijuana. Now, it's going to be curious to see what happens when the new administration comes in beginning of the year, and to see if we start having federal enforcement of the marijuana law and going back and enforcing what's already on the books. Because remember, if the federal government has just recently ruled again and kept marijuana on the same restrictive list of drugs as heroin, then the states don't have a legal right to create a law and say you can sell it. It's just it's not being prosecuted at the time. So right after we end this course and the new president comes into office, it'll be curious to start tracking during the next semester to see what's going to happen with these marijuana laws, and are people going to come in and be prosecuted. So does that make sense to you? Does that sovereignty make sense? If it doesn't, let me know, and we'll go over it a little bit more. Now, One more thing I want to talk about. I'm sorry, but this week you're going to get a lot of lecture from me, just because there's not a lot of like YouTube videos and all that breaks this stuff down really good. I sent you some of the good basic ones, but I want to make sure you get the stuff right. And I want to talk about the different kinds of laws. And there's statutory law, case law, and common law. Excuse me. Now, when we talk about statutory law, what would statutory law mean? It means statutory law is law that is created by the state or federal legislatures and is codified, meaning it's put into code. So if any of y'all have taken like the criminal law class and you see the big thick code manual, well, that would be the statutory law for the state of Georgia. Same thing goes for the federal code. It's what either the federal legislatures, meaning Congress and Senate, or the state legislatures have voted upon and written into law, and it's been approved by the governors or it's been approved by the President of the United States, and it's codified, it's put into statute. It's officially written down and made a law. That's what statutory law is. So what would case law be? Well, case law is where you have, let's say you have legislation on the books and you're doing things a certain way or whatever, and let's say something makes it all the way to the Supreme Court, okay? And the Supreme Court makes a decision on how things should be done. And it kind of changes what the view of that statute was. So let's say Congress passes a law, and then somebody appeals the constitutionality of that law, and it goes all the way up to the Supreme Court. And the Supreme Court looks at it and says, you know, we're going to adhere to that all except for these few points because these few points aren't constitutional. So we're going to send it back to the lower courts to change their opinion on it. Well, that's called case law. Case law is where you have these Terry versus Ohio is a good example, where you have these case laws that come out, and it court is why it's called case law. The courts decide what the interpretation of that right or legal law is, and that's where you get case law. Okay, and in the book it says case law is promulgated in cases decided by the courts. So basically, case law means it's how the courts determine, or what the courts determine the constitutionality of a statutory law to be. How the courts tell you the statutory law should be enforced. Okay, so once there's a Supreme Court ruling, or Georgia Superior Court ruling, or Georgia State Supreme Court, I mean, normally these cases come out of the U.S. Supreme Court. Once you have that ruling come out and they make a decision, that becomes case law. And Terry versus Ohio is a really good example of how they turned a process into case law, and that's now what we follow when we're carrying out our duties. And then you'll hear common law. I'm not going to worry about common law a lot in this class. Common law goes back to it's almost like moral code. Common law goes all the way back to ancient England and back to what was traditional law, meaning it may not be exactly written down, but we know inherently you're not supposed to do it. Just for, say, an example, you may not have anywhere written in a statutory law that murder is wrong. But common law, by practice, by moral code, we all understand moral is wrong. So if you were in a place where they didn't have a specific statute saying you cannot kill your fellow man, without reason, then you go to common law because we know it. I mean, we just know that's something that goes back to Moses and the Ten Commandments and all that. We've known since Cain killed Abel that's something you weren't supposed to do. Okay? I'm going to stop there because I've given you guys a lot, and I really hope this recorded because I don't want to do it again. So I hope we got it. If you guys have any questions, hit me up. I'll be glad to answer anything online, and we'll go from there. All right, guys. Thanks, and I will talk to you later.